Assistant Public Defender on behalf of Mr. Bailey, who is joining me at the podium.
Your name, sir?
Matthew Bailey.
All right, what are we doing?
Your Honor, Mr. Bailey would like to demand his exam.
Is all discovery complete?
I believe so, Your Honor.
People have their witnesses available on the 9th? So you beat me. I do believe. Preliminary examination in this matter in person will be set July 9th, 2024, 9 a.m. That is before me. Bond will continue.
Your Honor, may I address bond?
Briefly.
Your Honor, Mr. Bailey was ordered to turn himself into the Washington County Jail. He did so, I believe, approximately 12 to 13 hours later than he was ordered by Magistrate Fink. At this time, we would ask Your Honor to reconsider. I think a GPS tether would provide a guarantee of safety to the community, especially with the
Why didn't he turn himself in on time?
Well, Your Honor, I think he has ties to the community. The tether would keep everyone safe, and he's not able to.
I don't know that answers my question.
Could you repeat the question, please?
Why didn't he turn himself in on time?
He had childcare issues.
For 12 to 13 hours?
That's what he told me, Your Honor. I mean, he needs to find alternate childcare. It's not just.
Go ahead. Anything else?
No, Your Honor.
I don't need a response from people. Motion for bond reduction is denied. Bond will continue as it is. Thank you.
David I. Goldstein, appearing on behalf of the defendant.
Your name?
Gregory Williams.
What are we doing?
Setting for an exam, Your Honor.
Discovery complete on this one?
As far as I know, yes, Your Honor.
People have their witnesses available on the 9th.
We'll do our best.
Preliminary examination
That date's fine, Your Honor. Thank you.
in person will be set July 9th, 2024, 9 a.m. That is before Judge Burke.
Your Honor, I'd like to address the court very briefly on the issue of bond. When bond was set in this matter, Mr. Williams was ordered for a GPS tether. I would indicate to the court that I represented Mr. Williams on a circuit court matter that went for over a year. It was ultimately dismissed by the people, and there was never a problem with him on bond. He wasn't on a tether on that one, but there was never any issue with him appearing. There was no complaints about his behavior or anything else like that. Given the nature of the charge in this case, and given the fact that he has never had a problem with complying with the court's bond, we're asking the court to drop the GPS tether requirement.
Is the GPS a location tracking? Or?
That's right. Tracking location?
Yeah.
Yes.
Response from the people.
That in this case, it is a DV case. The standard, as far as I'm aware, in DV cases, but more than that, the defendant and the victim got into an argument over child custody issues and court related to the child custody. The defendant got upset at the victim as well as other passengers in the vehicle, and he attempted to run them off the road and made an abrupt stop, causing the next word and hit them by another car. Both the victim, who is the domestic violence, or who is he has a romantic partner with, as well as one of her friends, and their children were in the vehicle at the time. I am extremely concerned at the nature of this case, and I would be opposed to modifying. He's already out. I think a GPS tether is appropriate.
Your Honor, if I could address briefly, because I made a mistake. He's on a house arrest. We're asking the court to make it a GPS location. At least he was told by the tether people there was. My notes don't reflect that from his arraignment, but he was told by the tether people
That he's on a. I do have him on a home confinement tether.
We request $100,000 at at the outset, we would prefer to state custody. I think home confinement is appropriate.
Well, they set it at 50. He posted, when is the exam set? On the 9th. At this point, I understand your position, Mr. Goldstein, but what I'll do is I'm gonna leave what is in place, let the exam happen, let Judge Burke make that decision after. So I'm gonna deny your motion at this time.
Thank you, Your Honor. That's Judge Burke.
Yes, that is before Judge Burke.
The public defender, with and on behalf of Ms. Brown.
What are we doing?
Your Honor, this time, we are still in the process of plea negotiations. We're hoping for some sort of specialty court resolution. We would like to address bond and as well as get an adjournment.
How much time are you gonna need to try to get all of that done? She's got 8 cases, I think, here.
That is correct, Your Honor. The last communication I had with the prosecutor's office, they were doing some internal discussion as to whether or not they would agree to the referral to the specialty court. So with that,
July
I've asked for-
18th, 2024, 9 a.m. as to bond.
Your Honor, we, Miss Brown is a community mental health. Pardon me. Okay. She is a community mental health customer. She is also, if you look at the dates, most of these are, some of them are quite old. All of these incidents occurred around the same time or in that same time frame as right after her mom's death, as well as her son being diagnosed with stage 4 renal failure, as well as her house being on fire. Prior to that, she had had at least a year of sobriety. She had her own home. She was working, and she went back to her mom's home in order to take care of her. And that was a very big trigger. At this time, she is working very hard and has made some good progress towards getting her life together. She does have her own place. She's been working with Avalon Housing and recently got that. She's recently reconnected with community mental health. She would like to, if the court would consider allowing the opportunity for her to return home with a tether, she would have no objection, and to begin to get into some sort of treatment that way.
Any response from the people?
There's a bond recommendation form filled out by Assistant Prosecutor Rachel McDuffie. And if the court has had a chance to review that or has it in the file, the prosecutor there outlined flight risk and dangerous driving aspects of the defendant's behavior over the last few years. And included in that summary, Your Honor, and I'm not going to go through everything because I know you've had a chance to review it. While on bench warrant status here for the Washington County cases, she entered a guilty plea to operating while under the influence of drugs in 34th District Court, February 17, 2023, and has another bench warrant for failure to comply with the PSI on that misdemeanor case. So there's a lot going on with her, and I just don't think it's a good decision right now to release her to the community, especially if they're contemplating some type of treatment or specialty court. She needs a lot of services in place to support her before we can let her go back.
And she was before me, I think, yesterday on this case. And so I'm actually very familiar with this defendant. And at this time, I'm going to deny the motion for any type of bond reduction. There'll be no release. Get this worked out and make sure that everything's in place for her. All right. The motion for bond reduction tonight, July 18, 2024, 9 a.m. Bond continued. All right, go ahead.
Good morning, Your Honor. Deborah Geraldine Bledsoe Ford on behalf of Jabar Harris, who stands to my right.
Your name?
Jabar Harris.
All right, what are we doing?
We're asking for an adjournment. I just got appointed on this matter. I ordered discovery, don't have it. So I'd like to share the discovery with him, and I expect that we will hold the preliminary exam.
Probable cause conference, July 11th, 2024,
Thank you.
9 a.m. Bond continued. Thank you.
Oh, excuse me. He did ask me to address bond. He wanted me to tell you that he, I believe, has had one prior UIL, was on probation for it in Clinton Township, was in compliance with it, that this matter emanated from his baby's mama, and that he feels that it's contrived, and he stands in not guilty plea, and that he is employed as a chef at a Bebo restaurant, bar and grill in Mount Clemens. His boss is Scott, and this can be confirmed. He was working at the time of his arrest. Is that correct? Anything else?
I'm sure there's a response. Go ahead, Ms. Blanche.
He actually has a 2019 conviction for reckless use of a firearm. He also has an OWI from 23. There's a couple of things I first. He is in Westland and home.
Oh, can I just hold for holds or arrests or contacts? I know, holds as in he's evaded court or?
No, like they have probably there's warrants out for various tickets.
Traffic?
I don't know. I can look it up in a second.
All right, well, traffic.
Judge, he has, we requested a $200,000 bond on this matter. The magistrate at the time gave $100,000, 10%. This case, I was extremely concerned. I was the one that wrote the warrant on this case. He actually took his car with his minor children in it and hit the victim in this case and tried to run into a truck on the highway. When he pulled off the highway, stopped at a gas station, he then tried to pin her up and run her into the pumps at the gas station. The kids were in the car. The kids are all both under 2 years old. Extremely concerned. So I asked you not to change bond. We had asked for a higher bond. I think that would have been warranted.
He says that those allegations are contrived, and that the video at the gas station can substantiate it. That she was nowhere near him when he accidentally had the car in reverse. She wasn't. He
accidentally put the car in reverse.
No, it was already in reverse.
Oh,
It was already in reverse. He says that the video will substantiate that, and she was nowhere nearby.
okay. Anything else?
No,
Motion for bond reduction denied. Bond will continue.
thank you.
To the podium, could you please state your name for the record?
Joshua Smith.
Thank you.
Your Honor, today is the date and time set for a PCC in this matter. We would be asking for an adjournment of the PCC to complete discovery in this matter. I have gotten some initial discovery, but I believe there is more coming after speaking with Madam
That's the
Prosecutor.
only thing holding him.
I'm sorry, Your Honor.
It's the only thing holding him.
Yes, it is, Your Honor. And we would like to address the matter of bond when the court is ready.
Cause conference, July 11th,
July 11th.
2024, 9 a.m. Or as your invite indicates.
Thank you, Your Honor. May I address the matter of bond, Judge?
You may.
Your Honor, Mr. Smith has no prior convictions other than possibly a driving while license suspension case. I did run his iChat and it was completely clean. He's been incarcerated for 9 days since June 18th. He has retained counsel and is serious about facing the matters in front of him. He's a 30-year-old man that lives in Ypsilanti and has an apartment he's prepared to go home to. He's a lifelong resident of the Metro Detroit area, growing up in Canton and graduating from Plymouth High School in 2013. He has extremely strong family support in this matter. His mom, dad, and sister all live in Canton, and his extended family out of the state has been calling to check in on Mr. Smith and help in any way they can. His mom is a assistant deputy director of field operations for the Michigan Department of Correction, essentially in charge of supervising parole and probation, or parolees and probationers. His dad is a retired worker from DTE Energy. His parents have borrowed from their retirement in order to retain counsel on his behalf. Speaking to Mr. Smith's work background, he's obviously resigned from his job due to this case, but he has been consistently employed since his senior year of high school, working in various industries like food service, manufacturing, trucking, and hospitality. He is confident that he can become employed should he be released in this matter, and he does believe he has a lead on a case or on a job to become a janitor. I have had a chance to review the police report in this matter. Judge. And I would note that there's no mention of any injury to the complaining witness or no mention of any medical treatment. And based on that police report, I've done a preliminary run of his sentencing guidelines, and assuming for the sake of this bond argument only, that if you were convicted of assault with intent to do great bodily harm and you were given points under OV3 for bodily injury requiring medical treatment, maximum points for psychological injury to the victim, and maximum points for exploitation of a vulnerable victim, his sentencing range would still be 0 to 17 months, meaning it would be an intermediate sanction since it's an under 18-month sanction. And as this court is well aware, jail is not an intermediate sanction. So that presumptively this would be a probation
I
sentence.
understand how
even if
sentencing
convicted.
works. Go ahead, get to your end of your argument.
Okay, concluding, Your Honor, I would note that there was 14 days between the arrest and the incident in this matter where there were no allegations of wrongdoing. Mr. Smith was proactive in looking out and getting a booked therapy appointment, which he would like to get back to. We'd be asking for a cash bond that Mr. Smith can afford because we do not believe he is a danger to the community or a flight risk. We'd ask for a $2,500 10% cash bond in this matter, Judge.
Response.
Your Honor, we originally requested a $75,000 cash as surety in this case, and we were given $75,000 with 10% privilege. This is a case that was completely captured on video. The defendant was a teacher at Ypsilanti High School. The victim in this case was a 14-year-old student. Here, the victim and the defendant appear to have gotten into a verbal argument. At one point, the defendant instructed the victim to do push-ups. The victim told the defendant that he was unable to do so because he had a wrist injury. And then at that point, the defendant got in the 14-year-old's face and said, "That's some bitch ass shit." The defendant then followed the victim as he started to walk away. And at that point, he strangles him for several seconds with the sleeve of his sweatshirt. It was only when two teachers walked up and intervened that this concluded. The whole thing is on is on video. And aside from the physical acts of the defendant, what is extremely concerning is that in his own words, in his statement to law enforcement, when asked what happened, he said he had a headache and he snapped and he knew it wasn't right. So I'm significantly concerned based off of the nature of the physical acts, which were all caught on video, but also the defendant's own admissions here about what exactly happened.
May I have a brief rebuttal, Your Honor? Even with the
There
series,
was a 14-year-old, he was a teacher, and there was a strangulation.
those are the allegations, Your Honor.
Yeah,
And
go ahead with your response.
even with the seriousness of these allegations, we fully recognize the seriousness. I think the guideline argument remains that this still is a presumptive probation. And I think to the danger of the community, I think the 14 days between between the incident and arrest where there was no court order in place, where there's no allegations of wrongdoing, speak to the danger of the community that Mr. Smith is. And I believe that that danger can be mitigated with reasonable terms of bonds, such as possibly a tether or a cash bond that he may afford, which we would ask for 2,500, 10%, Your Honor.
There's a 75,000, 10% bond.
I understand, Judge.
They didn't request that I raise it. I actually should raise it, given what I've heard. I will not. However, your motion for bond reduction is denied.
Your Honor, would you consider release if he was to live at his mother's house rather than by himself in Ypsilanti as a condition of bond?
Did I thought I ordered something.
I was just asking if it would sway your decision at all, Your Honor.
No, when I'm done, I'm done.
Fair enough, Judge.
Thank you.
Thank you, Your Honor.
Those are all recalls.
Yes.
Then I'm gonna
Kenneth Overwater,
take
Assistant Public Defender on behalf of Mr. St. Germain.
Your name, sir?
John St. Germain.
Thank you. What are we doing?
Your Honor, I'm be asking to adjourn the probable cause conference. I still need video on the new case. And I would ask to address the issue of bond.
July 11th, 2024, 9 a.m. The probable cause conference as to bound.
Your Honor, a warrant issued for my client when he failed to appear for court in the last couple of weeks. He was at that time homeless, residing in Hamburg, Michigan. He did not have transportation to get down here. That's all why he was not testing at the time. However, he has been able to resolve that issue. If released, he'd be staying at an address in Whitmore Lake with a couple friends of his. My office has spoken with these people. One of the people who resides there is a social worker. She did confirm to our office not only that Mr. Saint Germain can stay there, but also that she would be providing support for him for his sobriety. She and her partner would also provide transportation for him so that he can get to testing and get to court. He did try to get down here to turn himself in. He was actually walking to Ann Arbor when he was arrested. He is not a flight risk. He insisted that I inform the court that he meant no disrespect to this court when he failed to appear. He does admit that he has a drug problem, and that is something that he is working on and will be entering into outpatient treatment as soon as he gets out of custody. And again, does have the assistance of a social worker with whom he could reside.
He didn't appear here and he didn't turn himself in. What was he picked up for?
Oh, can I?
Yes,
Explain that?
go ahead.
That's the new case that you have today.
Got it.
The officers from Rosefield Township saw him. A call had been made about a suspicious person checking into windows of cars. Somebody saw him doing this, called them up. They looked at him, saw that something didn't seem right. They confirmed he had a warrant. He resisted arrest. When they arrested him, they also found controlled substance in his possession, specifically methamphetamine. He was discharged from MDOC earlier this year, it's my understanding, for a prior home invasion first attempt conviction. The reason for the discharge was probation violation, technical violation. He has 8 misdemeanor convictions in addition to the aforementioned felony conviction. There's also a 7411 that he received for possession of meth, which I believe is 2021, fairly recent. Guidelines are 5 to 23 on the Class D felony.
Got it. Motion for bond reduction denied. Bond will continue both matters. Thank you.
What was the date for probable cause?
July 11th.
Jessica Blanche, appearing on behalf of people.
Assistant Public Defender Dave Owens on behalf of Mr. Harris, Your Honor, who appears via Zoom. Mr. Harris, can you please state your name for the record?
Jabar Harris.
Thank you.
Your Honor, we are asking to set this matter for examination today. It's also my understanding that there's been an allegation of a violation.
Yes, Your Honor, I'd like to address that when appropriate.
You want this set for preliminary examination?
Yes, Your Honor.
What's the bond violation at this?
When he was in custody, he had called the victim over 24 times. He had requested a $50,000 bond on this case. The magistrate gave a 10% provision. He was released. I thought he was on a home confinement center in Kunky because he has a pending case up in circuit court where there's concealing firearm, a CCW. He's on height of probation. The thing that's concerning is not only he's contacting the victim, but the nature of the calls, the first original call after he was arraigned, the first thing out of his mouth is he calls her a bitch and says, "I'm going to beat your motherfucking ass." She says, "Hey, don't say that."
Huh?
And then there's another call where he's telling her to post his bond. And he says, "I'm going to slap the fuck out of you." What? So I'm concerned. Not only these calls, he's calling the victim, violating his bond, but then the nature of the calls, what he's actually saying to her. After he's out, it's a gift.
He needs to be here. He'll have,
Understood.
I want him here at 1 o'clock today.
Understood, Your Honor. I just learned that these allegations are.
Sir, you need to report to the court at 1 o'clock today.
Thank you.
What court?
14A.
Where's y'all located at?
14A1. We're right by the
What's your-
sheriff's department.
Okay,
Right by the
jail,
jail,
said-
Mr. Harris.
okay, report to court. Excuse me?
Court calls the case, People versus Cartrell Rob. I know how to be. This is. Court does call the case. People versus Jabari Harris. Yeah.
Good afternoon, Your Honor. Assistant Public Defender Jay Bellinger on behalf of Mr. Harris, whom I don't see here. I believe he's playing Pac-Man, Your Honor, and that he's ghosted us.
Okay. I don't even know what to do with that. I mean, I understand what you're telling me. I did order him to be here at 1 o'clock today, given the bench warrant will issue for defendant's failure to appear for this hearing. And given the allegations in the bond violation, bond will be set at this point at no bond.
Thank you, Your Honor.
Judges, the plenary exam is still set.
Pardon?
The plenary exam is not still set, correct?
I have not said it. I've not said anything.
Thank you. Thank you.
I thought he was.